Yes.
My Lords, I was going to move to Article 7.2 of the Process Regulation, which is the cautious provision. And this section is dealt with in paragraphs 170 to 173 of our skeleton argument. And I'm proposing to take it briefly. The article provides that a person domiciled in a member state may be sued in another member state in matters related to tort, delict, or quasi-delict in the court of the place where the harmful event occurred or may occur. That article encompasses all non-contractual claims, and it is the club's case that the harmful acts in question are Spain's registration of the Spanish judgment and its pursuit of that registration application. Once again, therefore, this ground applies only to Spain, not France, because although France have taken preparatory steps for registration, they haven't applied for registration as things stand. The acts relied upon took place in England, and the harmful event which may follow, namely the enforcement in England of the judgment after registration, if the club's appeal is dismissed following the reference to the CJEU and there are thereafter enforcement proceedings, will lead to harm suffered in England. Spain, for its part, asserts that the harmful event is and remains the Spanish judgment, and that event occurred in Spain, not England. But in my respectful submission, then firstly, there are continuing acts in England which are harmful events and breaches of Spain's obligations, and secondly, that the harm which will follow from those continued breaches will be suffered in England upon registration and enforcement in England. And in my submission, then Spain has no real answer to this latter point. The point is as short and sharp as that, and I will be proposing to take up any further time.
How can enforcement of an English judgment in England be regarded as harm?
Because you have to then pay pursuant to that enforcement.
Well, I understand that you have to pay money, but how could it, as a matter of analysis by this court, be regarded as harm to enforce an English judgment?
Because of the fact that the judgment should not have been obtained, because it followed from wrongful acts on the part of Spain in obtaining the Spanish judgment.
Again, how could this court, how could we act on the basis that an English judgment had been obtained wrongfully?
Because by definition, and this obviously goes to the merits of the claim rather than the jurisdiction question, but by definition, if the judgment which is then enforced is a judgment which should never have been obtained,
we can't look behind that, can we?
Yes.
We can't look behind
that. That's the very nature of the action. Because the nature of the action is that matters should never have come to this. And that is so in relation to all of the club's actions. All of them proceed upon the premise that the Spanish state should never have carried on in Spain in breach of its obligations. Had it not in Spain in breach of its obligations, it would never have obtained the judgment. It is the judgment which is the culmination of its wrongful conduct. The mere fact that that judgment, if it be improperly enforceable, it is one which, in those circumstances, the court would enforce, doesn't prevent the act of Spain in obtaining and enforcing it from being wrongful. And the consequence would be that the club would have a cross-claim in the enforcement proceedings on the footing that it has an equal and opposite claim to the claim that Spain brings, on the footing that the judgment that Spain has obtained is one which should never have been obtained and was only obtained in breach of contract. The situation is exactly similar to the situation which appertained in the Alexandros T. Your Lordships may recall in that case, which went to the Supreme Court and again to the Court of Appeal, that was the case in which there was a Greek judgment an English exclusive jurisdiction agreement, by virtue of which the English courts had jurisdiction to award damages arising out of the breach of the exclusive jurisdiction clause by virtue of the bringing of the Greek proceedings. So it's an exactly similar situation in the Alexandros T.
Was it a Greek judgment which had been registered here or was going to be? I can't remember.
It was a Greek judgment that it was anticipated would be registered here. At the relevant stage, then, your Lordship may well recall, but the matter went to the House of Lords in relation to the question of whether there should be a stay because the matters were related proceedings. And the House of Lords held, or the Supreme Court held, that the proceedings were not related proceedings. In the Supreme Court, then, Lord Newburgh posited the suggestion that as and when the judgment was actually rendered and registered, that in turn would give rise to a right to claim damages vested in the counterparty on the footing that the judgment should never have been obtained because the obtaining of the judgment, bringing of the proceedings which led to that judgment, was in breach of the exclusive jurisdiction clause. What then happened was the matter went back and forth. Justice Burton ordered that a fund be set aside, out of which the party could then seek indemnity on the footing that the obtaining of that judgment was in breach of the exclusive jurisdiction clause, and that the relevant party was therefore obliged to set up a fund which would be available to compensate the wronged party for the breach in bringing the Greek proceedings. And that judgment was upheld by the Court of Appeal in a judgment of Lord Justice Longman. So I would submit with respect that the club's claim is a perfectly understandable claim, which is supported by authority, and the mere fact that if it be the case, and of course we don't know whether at the end of the day the Spanish judgment will be registered or indeed enforceable, but the whole point is that if the obtaining of that judgment is as a consequence of a breach of a relevant contractual or quasi-contractual, in this case, obligation, quasi-contractual, or use the word my Lord Justice Mayo used in the Airbus case, obligation equivalent to contract, then in those circumstances, then there is no reason why the club should not obtain relief in the opposite amount to that which the English court orders by way of registration of the Spanish judgment.
But the court will already have decided that there should be, if that's the stage that's reached, the court will have decided that the judgment ought to remain registered and enforceable here, notwithstanding that it was obtained without complying with the obligations that are declared in its Section 66 judgment, won't it?
No, it won't determine that, my Lord, because that's not a relevant question for the purposes of the regulation. So the relevant question for the purposes of the regulation is simply whether the earlier or the English judgment, whether earlier or not, is inconsistent or irreconcilable with the Spanish judgment. The decision in that regard has nothing to do with the question of whether or not the judgment that was obtained in Spain was obtained in breach of a relevant arbitration or jurisdiction agreement. It's simply not a relevant issue for the purposes of the registration determination.
Because whether you could have or couldn't have, and presumably you decided that you couldn't, you have not said that that makes it manifestly contrary to public policy. Your public policy points were to do with
Yes,
get a fair trial in
that's
Spain.
right, and we couldn't say that anyway.
No.
Because, well, we couldn't say that indeed in the light of argument that, your Lordship will recall the argument that Mrs. Justice Gloucester accepted in the Wadi Suda was that acting contrary to an arbitration agreement was actually contrary to public policy, so as to lead to the availability of remedy of non-registration of foreign judgment. That decision was overturned in the Court of Appeal, although the Lordship will probably recall Lord Justice Waller said that that ought not to matter because of the fact that an English judgment which stated that there was an obligation to arbitrate should take precedence as irreconcilable under Article 34.3, and that is the issue that has been referred to the European Court. And that's a separate issue, the question of whether a party can obtain damages for breach of the obligation, which has led to the obtaining of a judgment which is under the regulation scheme enforceable, given that the regulation scheme only entitles you to look at certainly limited questions as a defence to registration. My Lords, then, if I can deal very briefly, I hope, with Article 8.2 of the regulation, that's the counterclaim article, and just a number of propositions here, conscious of the time. The first point is that there is a distinction, as I already indicated, between, on the one hand, jurisdiction under the regulation, and on the other hand, case management. Case management is a matter for the national law and not for the regulation. Secondly, then, merely because a particular jurisdiction may, as a matter of case management, decide to hear the claim and counterclaim separately, should not impact on the allocation of international jurisdiction, which is what the regulation is concerned with. That appears from the case of Nortatova against Balthazar. Just for your Lordship's reference, that is tab 31, bundle E2, at paragraph 28. Thirdly, as a matter of first principle, then an action to enforce a judgment would be an original claim. That appears from the Altimo Holdings case itself, bundle C2, tab 28, and there is no reason to distinguish in this regard between an action of common law and an action pursuant to the regulation. The state suggested from the perspective of jurisdiction. Fourthly, then the suggestion that a counterclaim cannot be brought against an enforcement proceeding has no support in the authorities. I won't take up time in taking your Lordship through the relevant paragraphs, but they are paragraphs 153 and following of our skeleton. Next point that is taken is one of timing. The states argue that the registration proceedings were not pending when the judgment claims were issued, because an order had already been made in relation to those proceedings, but of course there is a pending appeal, which means that the proceedings still are pending. So, in my submission then, the claims which the club makes are, broadly speaking, counterclaims within section 8.3 of the regulation. That's to say, they are claims arising from the same facts on which the original claim was based, and can therefore be brought in the same court in which the original claim, namely the registration proceedings, are pending. Lastly, my Lords, then, the section 18 application, and I can deal with this very briefly. If, as the club contends, then state did not enjoy state immunity in relation to the section 18 application, then Spain still, as we understand it, seeks to appeal from the judge's decision to appoint an arbitrator. That's paragraph 5 of its grounds of appeal. There are two issues that arise under this head. The first is whether the Court of Appeal has jurisdiction to set aside the judge's decision to appoint an arbitrator, given that the judge did not grant permission to appeal from his decision. The second is whether Spain can successfully get around that prohibition by arguing, as it does, that the matter before the judge was not in fact a Section 18 application at all, but was an application to set aside permission to serve the Section 18 application out of the jurisdiction on the basis that the Section 18 application had no real prospect of success. So, dealing with those 2 points briefly, firstly, whether the Court of Appeal has jurisdiction in relation to the judge's decision to appoint an arbitrator. The answer to that question, my lords, is I would submit, obviously no, in the light of Section 18, subsection 5 of the Act. That's the one that states that the leave of the court below is required for any appeal from a decision of the court under this section, i.e. Section 18. That is one of the provisions of the Act designed to ensure that speed and finality in arbitration are not compromised by excessive court interference, as the court will be well aware. I have, with gratitude to the court, looked at the Manchester City case that we were referred to. That, I would submit, does not detract from the general principle that I have just identified. There, the decision was that the decision as to publishing of the decision was not actually one of the matters that fell within the requisite prohibition, because it was not actually a decision under Section 67 itself, nor was it impacted upon by the considerations of speed and finality, which led to the provision in Section 67. And indeed, Mrs. Justice Mulder made the point that because those points did not seem to her to apply to the decision that she made on the publicity, she thought that the Court of Appeal should have jurisdiction to deal with that severable point. Here, conversely, the decision is the very decision itself to appoint an arbitrator. It is clearly a decision within Section 18 against which the appeal is brought, and it is clear that that is one of the sections in respect of which those considerations of public policy apply. The second point that Spain raises is, as I've indicated, that the judge wasn't dealing with a Section 18 application at all, but was dealing only with an application to set aside the service for, the order for service out of that Section 18 application. That argument, with great respect, ignores the realities of the situation and what in fact happened in front of the judge. It is quite true that Spain applied to set aside the order granting permission to serve the Section 18 relief out of the jurisdiction on the basis that that application for Section 18 had no real prospect of success. The application to set aside service out was refused, as is apparent from the terms of the order. At the hearing, however, of the Section 18 application itself, Spain treated the hearing as the Section 18 application, as did the club. That is apparent from the skeletons served by each party, which are at Supplementary Bundle 1, tabs 9 to 12, and it also is apparent from the fact that there was full argument on the application, as is apparent both from the skeletons and the transcripts, and indeed the judgment itself, the latter being at Core Bundle 1, tab 37. The judge made an order not only on the application to set aside, but also on the Section 18 application itself. That's paragraph 2 of his order at tab 36 of Core Bundle 1. And logically, of course, it follows from the judge's conclusion that an arbitrator should be appointed, that the club had a real prospect of getting a judge to appoint an arbitrator pursuant to section 18. The proof of the pudding was very much in the eating. Not only did it have a real prospect of obtaining such an order, it did obtain such an order. So, in my respectful submission, then the appeal in relation to the section 18 order should be dismissed. I will think that unless I can be of any further assistance, those are all the submissions that I wanted to make to your wishes.
Thank you very much indeed, Mr. Hancock. Well, you've waited very patiently, you're still not, but it's your turn now.
Yes, long awaited start. Well, I'm grateful to Mr. Hancock for being so precise. May it please the court, in terms of what I'm actually addressing, I will be addressing whether the judgments claims and the awards claims fall within the recast regulation. And I will also, if time is available, deal with the merits of the judgment claims. Now, those only principally become relevant if we are outside of the recast regulation, so that we are, if you like, within the arbitration exception. But they do also come back in, or some of them do to an extent under the recast regulation, because when the club is seeking to establish jurisdiction under Article 7.1, so the performance of a contract within this jurisdiction, one of the elements that they have to pass through is that there is a serious issue to be tried, or a serious arguable case that there exists a relevant contract which is to be performed within the jurisdiction. So if there's no arguable case that there exists a relevant contract which is being sued upon, the court in my submission can't take jurisdiction under Article 7.1, and that is common ground, and that is found in paragraph 182 of the club's skeleton.
So far as the awards claim is concerned, you're going to tell us that they fall within the regulation and therefore not within the arbitration exception. If, however, they are within the arbitration exception, are you simply going to rest on what Mr. Young has already said in relation to serious issue, or are you going to say any more about that?
My Lord, no, because after I have finished, Mr. Young will have to deal with whatever else he has to say on the merits of the awards claims, which I anticipate is not very much, as they've already been addressed to some considerable extent.
Yes.
And then, if you like, sweep up on the Spain-only points under the recast regulation, which should really be quite brief. So Mr. Young will make some additional submissions following me tomorrow, following which Mr. Hancock will have his reply.
Right, okay, so yeah, that's for him and not you, that particular.
Exactly, my Lord.
Okay, good.
And just for one further point of clarification, in terms of saying the awards claims fall within the regulation, my learned friend Mr. Hancock made some submissions yesterday to the effect that because by reason of the subject matter of the awards claims, they must fall within the arbitration exception. To be clear, we don't dissent from that proposition. The only way the awards claims can come within the recast regulation is if our argument on Assens Harvin is correct. That's the only basis. There's no other subject matter basis where we argue that they're within the recast regulation.
Right. And so far as the Section 18 jurisdiction point is concerned, is that you or Mr. Young?
That's Mr. Young.
Okay, well, we know the division of responsibilities now, thank you.
Exactly. So I am of necessity going to have to be relatively rapid with all of this. In terms of the analysis on jurisdiction, the way I proposed to order matters was to deal with, firstly, whether the claims are within the recast regulation, secondly, whether they are matters relating to insurance, so as to come within Section 3, and then as part of that, whether the states can properly be described as injured parties with the protection of Article 14 of Section 3, or whether they're being sued in that capacity. And if the matters are not relating to insurance, whether this court would take jurisdiction under Article 7.1, place of performance of a contract. So I've grouped recast regulation issues together because that seems logical, and deal with any issues as to serious issue to be tried at the end. Now, whilst I hesitate to ask the court to look at any pleadings on day 4.5 of this appeal, I would be grateful if we could just look very briefly at the club's particulars of claim in relation to the judgment claims, because one has to understand the nature of the obligation. So if I could just ask the court briefly to go to the particulars of claim which are at core bundle 1, tab 16, page 253. If I could ask the court to look at paragraph, I think it's 8, is the introduction, if you like, to the nature of the judgment claims. Paragraph 7, the club explains the nature of the relief which it is seeking in the arbitration, and it explains the claims it has brought, as it says on the awards, so the awards claims, and then at 8 it says, in addition to those claims, the club seeks in these proceedings declaratory relief that the Spanish state is in breach of its further and independent obligations to abide by the English judgment. And one notes there, of course, the framing of the positive obligation in terms of what we are to abide by. And then if I could ask the court to go to paragraph 77 on page 274 of the bundle, and sees in a little more detail the basis for the club's pleaded case. And this being in the case of Spain, France, the claim against France is indistinguishable. They say, further, the Spanish state is a party to the English judgment and or submitted to the English court proceedings and or agreed to be bound by the English judgment and is therefore obliged to abide by the English judgment in contract and or tort and or as a matter of common law duty and or in equity. And so the obligation sued upon is that to abide by the English judgment, and there are 3 bases upon which that is said to operate. The first is the fact of the judgment, and that it produces an actionable obligation to abide by it, and that is the reference to EDF Mann and Harrianto, which my learned friend Mr. Hancock referred to just before the short adjournment, which I will need to ask the court to look at briefly in due course because it just doesn't do what it's said to do. Secondly, the implied contractual basis, the second implied contractual basis, is the state's conduct in submitting to the jurisdiction back in 2013 when it participated in those proceedings and asked the court to decide the issue of the tribunal's jurisdiction. The club says that resulted in an implied contract that the states would abide by the result. That is based on a Supreme Court decision called Vizcaya, and what it requires the club to do is to establish not only an implied jurisdiction agreement, but a yet further implied agreement that the states would abide by the result of the litigation to which in which it had participated. The third basis, and this is what was not before the judge and is new before this court, is what is called the alternative judgment claims, which is that if and insofar as the awards or the obligation to honour the awards merged into the judgment, it follows that there must be an obligation to abide by the judgments. The earlier, the anterior obligation to abide by the result of the awards having been merged into the judgment. We say there's simply no authority for that proposition whatsoever, but that's the basis for that aspect of the contractual claim. And we say it's important to have in mind as we're going through the jurisdictional analysis what the precise obligations are the club is suing on in respect to the judgment claims. I'm not saying my song will not be that the juridical nature of the causes of action are the be-all and end-all at all for a jurisdictional analysis under the Recast regulation, but it's important to distinguish the obligations which are being sued upon from, firstly, the equitable obligation to arbitrate, which has been found to exist and was declared in the awards and the judgment, and which is the subject of the current arbitrations. So breach of that equitable obligation is currently being decided in arbitration. And it's also important to distinguish the obligations sued on in the judgment claims from the implied contractual obligation to honour the awards, which is the foundation for the awards claims. The club is suing on entirely different purported obligations in the judgments claim. And so, just in relation to the awards claims, none of those authorities that the court was taken to yesterday relating to the implied obligation to honour the award apply here. So the Bimbesti, Jarmen, Atlantic Electricity, they're simply inapplicable. And so if there is an obligation, it doesn't arise from the agreement to arbitrate, it doesn't arise from the particular submission of a dispute to arbitration or the award. So in short, we'll be saying we're just completely outside of this process.
So possibly for the alternative way of putting it.
That would be the only one, which, and I'll be saying in relation to that, well, yes, the source, if this were to be argued, the source would be the submission to arbitration. But the obligation itself, the content of it, is to abide by an English judgment, and that is sufficient to take you outside of the arbitration exception. So really, our case in a nutshell on the arbitration exception is the claims have moved beyond arbitration, and what the English court is being asked to do is exercise its ordinary adjudicative jurisdiction completely outside of an arbitration process. And that being the case, the arbitration exception is just simply inapplicable. Now, the first matter I was going to address relatively briefly is the applicable test, because there isn't a great deal of difference between the parties. Now, yesterday, my learned friend took you at some length through the various European authorities for the past 20 or 30 years. But in fact, the domestic courts, this court, in fact, and through transport, has formulated a test, having analysed and synthesised, if you like, those European authorities. It's in through transport number 1. And so this court, and I'll go to it momentarily, has already formulated a test following an analysis of the relevant authorities. And the point that is taken by the club is that, well, the front comor wasn't decided at the point of through transport. It came later. And they say in the front comor is important because it said that you classify, if you like, the subject matter of the proceedings by reference to the nature of the right those proceedings serve to protect. But I simply say, well, that has been the law since Van Uden. That principle derived from the European Court of Justice in Van Uden Maritime and was taken into account in the Court of Appeals analysis and through transport number 1. So if I could ask the court just very briefly to take up through transport number 1, which is in bundle A4, tab 43. And the statement of the test is at paragraph 47, which is on page 734 of the report. And I should just say that this case contains from paragraph 38 the analysis of the European authorities that I was just talking about, which borrows very heavily on the analysis of Mr. Justice Aikens in the Ivan Zagubansky. But where the Court of Appeal gets to, if you like, after that analysis is at 47. And what is said is that in the result, and referring back to the Ivan Zagubansky, Mr. Justice Aikens, in our opinion correctly, held that the question in each case is whether the or a principal focus of the proceedings is arbitration. That test seems to us to be consistent not only with the Atlantic Emperor, but also with the first instance decisions to which he referred, and we agree with him that the reasoning in those decisions is to be preferred to that in Heidelberg. They went on, another way of putting the same point is to ask the question posed by Mr. Justice Ricks in the Ji Su Hui, namely whether the essential subject matter of the claim concerns arbitration. We do not think that is any different from the test which seemed to Mr. Justice Clark to be correct in the Lake Avery, namely whether the relief sought in the action can be said to be ancillary to, or perhaps an integral part of the arbitration process. So we have there really sort of 3 ways of putting the same point. The or a principal focus of the proceedings, does the essential subject matter of the claim concern arbitration? And that's really how the test was put by the ECJ in the Atlantic Emperor. And thirdly, is the relief sought ancillary to or perhaps an integral part of the arbitration process? And simply, nothing said in the front Camor changed that analysis. It was said yesterday by my learned friend that the test is whether the judgment claims have at their root the purpose of the right to arbitrate. And that will be at page 184 of yesterday's transcript. But in our respectful submission, that is simply not the test at all. And the test is, as stated by this court in Through Transport number 1. And that is the test to have in mind when one is looking at the features of these claims. Now, the reasoning of the judge is set out at paragraphs 104 to 108 of his judgment. I don't think we need to turn it up. I can summarise it briefly. Firstly, he said the purpose, on the basis of the purpose of the arbitration exception, i.e. Exclusion of proceedings relating to the New York Convention and the curial role of the court, the judgment claims are simply too far removed from the arbitrations. He felt that the judgment claims depended quite specifically on separate causes of action arising out of and giving effect to judgments, not arbitral awards. Thirdly, he felt that those causes of action would arise out of judgments having no connection at all to arbitration, which is plainly correct, and that the obligations are said to have arisen out of judicial proceedings, i.e. by the states having participated back in 2013, and not as part of arbitration or the arbitral reference or an aspect of it. And we simply endorse the judge's reasoning, which is a classic application of the principles as stated in Through Transport. And the various aspects of the judgment claims which the judge, which affected his reasoning, were firstly the source of the obligations, which are the subject of the judgment claims, the proximity of the claims to the arbitration process, whether the claims would fall within the auspices of the arbitration exception, were we to be dealing with a foreign award, and lastly, what the court's role is in relation to these claims in this litigation. But considering the matter on the club's terms, which is that what one has to focus on is the right which the claims serve to protect, which Mr. Hancock says it's the right to arbitrate. And really all the club's arguments are variations on this theme. What is the right that these proceedings are serving to protect? We say they're not, even if that was the test, serving to protect the right to arbitrate. Damages for breach of the equitable obligation to arbitrate is sought in the arbitrations, along with an anti-enforcement injunction to prevent the states taking steps to enforce. Those proceedings are seeking to protect the right to arbitrate, and they are arbitrable. What is sought here is damages for having failed to comply with what is said to be a distinct obligation arising out of an English judgment. And the obligation sued upon is distinct from the equitable obligation to arbitrate, and distinct from the award, and distinct from any obligations anterior to or arising out of the award, save in relation to the alternative judgment claims. And insofar as an obligation to abide by a declaratory judgment has any meaning or content at all, which we say it does not, following this court's decision in Res of Arca, the obligations sued upon derives from litigation and judgment, simply not arbitration. So these claims are not about the arbitration before Mr. Schaff QC. They're not about the equitable obligation to arbitrate. They're not about the award. They're about the English judgments, and they exist entirely outside of the arbitral process. And in terms of what they're trying to achieve, and this really comes into the analysis under the insurance section as well, what the claims seek to achieve is the neutralization in financial terms of the Spanish judgment. Now, one of the additional points made by the club, and it's said to be one of the matters to which the judge failed to give sufficient weight, was the idea that these proceedings concerning judgments are really a form of enforcement of the award and enforcement of a Section 66 judgment, which is said falls outside of the scope of the regulation. And the club praised the decision, I think it's of Mr. Justice Waller in ABCI, where one had the equivalent of a Section 66 judgment granted by the French courts, which was sought to be enforced in this jurisdiction under the Brussels Convention, and it was decided, no, you can't enforce that under the Brussels Convention because it falls outside of the convention. Now, this is obviously not a point that the judge missed, because the fact that applications to enforce awards and convert them into judgments have been outside the regulation has been the case since the Schlosser report. It's been the case since Mark Rich. Enforcement of the award is obviously covered by the New York Convention and is thus outside Brussels, and an application to register a resulting judgment in the case of a foreign award and judgment also falls outside the Brussels regime. But that, in my submission, doesn't tell you what the answer is in this case, where the club is not, at least in the judgment claims, seeking to enforce awards or register a foreign judgment doing so. We're simply not in the territory of enforcement of arbitrary awards. And really, a further, we would say, key feature of the judgment claims is that it's a case of the club seeking to litigate new, fresh causes of action generated by the judgments themselves. And what is important is that the club is proposing to litigate the claims, not arbitrate them. So the judgment claims are not the case of this court exercising its supervisory or curial jurisdiction or seeking to support the arbitral process. This is a case of the court exercising its ordinary adjudicative jurisdiction, but simply these proceedings are an end in themselves. There is simply no intersection with any arbitral process. And whilst a further criticism that the club makes of the judge is that he took too narrow a view of what constitutes the arbitration process. We say, well, he didn't, because simply these claims have moved beyond arbitration. We're just completely outside of that process, and this is not an arbitral dispute. And furthermore, if one thinks about the nature of the obligations which the club is seeking to enforce, obligations said to arise out of the judgment itself, obligations said to arise out of prior participation in litigation, it's pretty clear that the causes of action relied upon will arise in many other sets of proceedings and in relation to many ordinary judgments which have nothing whatsoever to do with the arbitral process. I mean, in effect, in a case where there's a judgment on the merits and the losing party is inevitably probably going to be sort of party to that judgment, they will probably have participated, they could have submitted to the jurisdiction of the court. And by so submitting and participating, it will, on the club's argument, the party will have entered into a new contract and be held to be bound by the judgment. So if these obligations exist, then they're going to exist in an awful lot of cases which are completely beyond or have nothing to do with arbitration. And what we say about that is that if that pushes these claims anywhere. It pushes them towards an ordinary contractual analysis and away from an arbitration analysis. There are two more arguments raised by the club, which I'll just mention. One is they draw an analogy with an anti-suit injunction and say, well, that can be either related to arbitration or not. One looks at the right which it serves to protect in order to classify the subject matter. And secondly, they also say, well, court, imagine these claims were going to be tried. Their essential subject matter is going to be arbitration, and we can test that by the various issues that are going to come up in the litigation. And I'll just deal with those very briefly, if I may. In relation to the anti-suit point, the club says, and the reference is it's paragraph 95 of their skeleton argument, that what was said by, page 31, Mr. Justice Aikens in the Ivans-Bansky, is that the object of an anti-suit injunction in an arbitration agreement case is to make the defendants adhere to their contractual bargain to resolve the disputes by arbitration. Therefore, in those circumstances, the principal focus or essential subject matter for the claim of an anti-suit is also arbitration. And we would say, well, that's right. And indeed, that is the purpose of an anti-suit in that kind of case. It's to support an arbitration clause. But that's not what the court is doing, or rather what the club is doing in this case. Because here the club does not ask this court to support it in requiring the states to resolve the dispute by way of arbitration. It's not asking the court to refer us to arbitration or to support an ongoing arbitral process. It's asking the court to adjudicate itself on the substantive dispute and to determine the cause of actions and award damages. Now, the logic of the club in making this point is, in effect, anti-suits can be inside or outside, therefore actions on judgments, even though they could apply more widely than arbitration, can be inside or outside. But just look at the rights that they serve to protect. We say, whilst that must be right, certainly in the case of interim remedies, it's difficult to see how that could possibly be the case here, because these proceedings just simply aren't concerned with the arbitral process in any relevant way. There's not going to be an arbitration, there's not going to be an award to enforce, there's no Section 66 judgment to enforce, there's only an ordinary court action and a trial with a resulting ordinary judgment at the end of it. And the final point, which is the club's argument, which really goes to, I suppose, looking at arbitration as a legal subject matter, arbitration as a sort of subject matter in itself in terms of the law. They say that the trial, were it ever to happen, would consider detailed aspects of arbitration law. And at paragraph 95, sub-paragraph 3 of its skeleton argument, it lists out the various factors which it says the court should have mind to in terms of what is ultimately going to be considered. And just going through those very quickly, I mean, we say that, well, the court isn't really going to be concerned with any arbitration matters at all. It's going to be concerned with questions of general law, many of which have already been aired before this court, in terms of whether there exists a cause of action, failing to abide by an English judgment, and whether it sounds in damages. I suppose it may also be concerned with causation in matters of Spanish law, but that's nothing to do with arbitration. But in terms of the factors relied upon by the club, they say, well, the scope of the arbitration clause is going to be an issue, to which we say, no, it's not. I mean, the states have already been found to be bound by an equitable obligation to arbitrate under the prestige number 2, and the tribunal and the court also decided that that dispute fell within the arbitration clause. The clauses of action in the judgment claims are not arbitrable, so there's simply no question of them engaging the scope of the clause anyway. the club says, well, one's going to have to consider the governing law of the arbitration clause. But in the 10 years where this case has been going on, one of the, I think, probably the few points the states haven't taken to date is the governing law of the arbitration clause. In circumstances,
resist the temptation.
You're safe with me, certainly. I can't speak for others, but for my part, I think we're okay. I don't wish to give my learned friend any further ideas. But I suppose finally, in terms of looking at circumstances in which an arbitration agreement could be said to be breached, there's no factual dispute about that. It's simply the steps that the states have taken in Spain in relation to the Spanish judgment, and the steps, I suppose, that Spain itself has taken over here to enforce the Spanish judgment. So, really, there is no legal focused or arbitration-focused inquiry, no factual arbitration-focused inquiry. And so if one's looking at sort of pure just subject matter, not the nature of the claims, juridical nature of the claims linked to the arbitration process, one is simply not going to be getting into matters of arbitration in any relevant sense if the matters were to go forward. And really, so we say that for all those reasons, we are outside of the arbitration exception, and the judge was right for the reasons he gave. I should just deal with the club's new point, which is based on the submission to arbitration and based on the merger of the implied obligation to comply with an award into the judgment. So this was the point which wasn't made before the judge, and it really only arises if the state's case on merger of the anterior obligation into the judgment is correct. It's quite, I don't mean to be critical, it is quite difficult to find a clear articulation of actually what the case is in this regard, because it's not pleaded. I'm not taking a pleading point, but just in terms of one is to understand the juridical nature of what is being said. I don't think we need to turn it up, but in terms of the grounds of appeal, and for the court to reference, that is Core 1, Tab 10, page 214, and it's paragraph 3. The club says, further alternatively, insofar as the claims are premised on an extension to or replacement of the obligations to honour the awards, the claims are arbitration matters and the appeal should be allowed to that extent. And so just pausing there, I would say, at its highest, it's a point of limited application, because it would be the only element of the club's claims which would be able to escape the application of the recast regulation. And then the only other place really where it's set out is, and I'm afraid it may just be necessary to turn this up, it's at page 33 of the club's skeleton, and it's footnote 69. And it says, the club does not say that the awards themselves contain an obligation to honour a Section 66 judgment. This again, referring to our skeleton, misstates the club's case, which is that the obligation to honour the English judgment in this class of case arises from the submission to arbitration in the same way that the obligation to honour the awards arises from the submission of the dispute to arbitration, see the bombasti. Insofar as that submission gives rise to an obligation to honour an award as a matter of principle, it must also give rise to an obligation to abide by a judgment enforcing that award. That is, a fortiori, if the obligation to honour the award is, as the states contend, extinguished upon it being enforced in a judgment. Otherwise, the club's rights disappear into a legal black hole, which is what the states want, but which cannot be correct. So the idea is that the claims made by the club in the awards claims kind of infect and cross the line over into the judgment claims. and somehow thereby bring them within the sphere of arbitration, because one has the source of the obligation alleged in the submission to arbitration. But we say that even if the club has a viable claim based on the implied obligation arising out of the submission to arbitration, which they don't, which I'll come on to, it still doesn't fall within the arbitration exception, really for the same reasons that we've given in relation to the judgment claims, which is that while the source of the obligation is the implied submission, and it is linked, I suppose, by way of background and history to arbitration to that extent, it's still a claim to abide by a court judgment because it's a judgment. It's not a claim to honour an award. No arbitration process is involved. And of course, what the club says is doing, well, it's protecting the right to arbitrate. But what I think we would say to that is, being realistic about it, it is arbitrating. It's arbitrating already obligations to arbitrate. It's having an arbitration right now, alleging breach and seeking damages. So, and whilst it said, well, unless you allow us to have this cause of action, our claims fall into a legal black hole. I mean, nothing could be further from the truth. We've got one arbitration going on, we've got the awards claims, and we've got these claims, all seeking practically identical relief, apart from the anti-enforcement injunction, which is the distinctive feature of the arbitrations.
Well, you're not totally averse to the idea of a black hole, are you? I mean, you are
No, it'd be
resisting
wonderful.
jurisdiction in all three claims.
But being realistic, whilst we would love to put the claims into a black hole, there are arbitrations, and certainly for France's part, we are participating in the arbitration, and Spain is participating in its arbitration, all subject to reserve of jurisdiction naturally, but the parties are arbitrating. And the club is seeking the same damages and financial indemnification in the arbitration that is seeking in both the awards claims and the judgment claims before the court. So simply no question of the club being left without a forum to resolve its dispute or obtain relief if that is justified. So, which brings me to the end of the main section of the arbitration exception, which
Yes.
is where we say that we're within the regulation outside of the arbitration exception. Now, I come to the argument based on Assens, which only has relevance if we are found to be otherwise within the arbitration exception based upon an application of the test in through transport. So if the court has concluded that the subject matter, the essential subject matter of the claims is arbitration, this is, if you like, the state's only way of saying actually that would be an incorrect analysis.
So this argument then applies to the judge's claims if you're wrong on what you've said so far,
Yes,
and to the awards claims.
that's
and
correct.
that's your only point, I think you said, on the awards claim.
My lord, yes.
Yep.
Now, it's fair to say that I'm not the brains behind this point, but I'm going to try and do it some justice. But I am going to alter it slightly from the way it's put, because we put it in the skeleton on two bases, and I'm not quite going to jettison one of them, but I don't think it adds anything to the first. So the way it's put in writing is that if the arbitration does...
So which paragraph of your skeleton are you on?
forgive me, I should have written that down.
If you're jettisoning something or
Absolutely.
thinking about jettisoning something, then it's useful to be clear about that.
Absolutely. It is from paragraph 96 to paragraph 103, insofar as it relates to the judgment claims. There is a paragraph further on in relation to the awards claims, but it says nothing substantive in addition to what is said in these paragraphs. Yeah, I'm grateful that Ms. Thompson says paragraph 183 as well, we refer to it in relation to the awards names. So if I could just ask the court to look at paragraph 97 then of the skeleton, and one sees it sub-paragraph 1 and sub-paragraph 2, the way in which we have put the point which is essentially the arbitration does not apply as the club's claims fall within Section 3 because of the decision of the CJEU and Assens, which the court was taken to yesterday. But secondly, that the concept of arbitration under the regulation does not encompass an obligation to arbitrate arising out of the conditional benefit principle because of lack of consent. And it's that I'm not really dealing with as a separate point because I don't think it is a separate point. Now, the overall issue within this heading, and I'm going to take this quite quickly, hopefully, is really the question of whether the club and insurers more generally can avoid application of the recast regulation by including an arbitration clause rather than an exclusive jurisdiction clause. So in a way, you avoid the application of the regulation by attracting the arbitration exception by using an arbitration clause in your contract rather than the jurisdiction clause in your contract. The basic proposition that we start from is that there is no material difference between the effect of an arbitration agreement and an exclusive jurisdiction clause in terms of, in effect, what it does. They are both exclusive forum agreements. And if one looks at sort of domestic English authorities, they are treated by and large without any distinction, particularly when one is looking at the application or the grant of anti-suit injunctions and the application of the conditional benefit principle itself.
Well, suppose, just test it this way, suppose that the club had applied in Spain for a stay pursuant to the New York Convention, and suppose that Spanish courts had applied the same principles as the English courts would, the club would have got its stay, wouldn't it?
There's a Supreme Court authority in Spain for that proposition.
Yes, Mr. Young says yes, there's Supreme Court
Yes,
authority
well,
in Spain for that proposition.
He said that to us a while ago, and it follows, therefore, that the states would not have been able to say, oh, but look at Section 3 of the regulation, that entitles us to disregard an arbitration clause.
In light of Assens, we would.
Well, they would have been entitled to do. I mean, obviously not if they had themselves applied on the basis.
The club wouldn't have got its stay then. The states would have said you can't have your stay because Section 3 trumps arbitration.
Well, they could have said that. I mean, it's open to them to do it in Spain to say. What's the state's case? Would the club have got its stay or not if it had applied, and if the same principles as in England had been applied?
Yes, it would have. The Supreme Court case and civil.
Oh, right. I'm just checking I'm not trespassing on Mr. Young's case by what I'm saying. Forgive me, the court. The state's case is that, yes, if the club had applied for a stay under the New York Convention in Spain, then the Spanish court would have upheld the arbitration clause.
So it follows that if the states had said you shouldn't be giving a stay because this claim is a matter relating to insurance and we are entitled to sue in Spain, that argument would have been rejected because unless the Spanish court is going to reject that argument, it can't give the stay.
But whilst I entirely follow your lordship's logic, looking at it from the perspective of what we're dealing with here and the application of the judgment's regulation, or rather the interpretation of the arbitration exception, it's open here for the states to say, well, the arbitration exception does not apply because in interpreting the arbitration exception, what the CJEU would do would be to look at Assens, look at the purpose behind Section 3, the protection of the weaker party, and construe the arbitration exception accordingly. I mean, that's really the point. All we're concerned with here is whether we're inside or outside of the regulation in relation to these claims. And in relation to these claims, we say, following Assens, that even though there's an arbitration agreement, although that's not being sued upon in relation to the judgment claims or the awards claims, we're outside of the arbitration exception. I mean, the starting point, as I say, is that there's no material difference between the two. In effect, they do the same thing. Now, what the club says is that's irrelevant, because once the case falls within the arbitration exception, you're outside of the material scope of the recast regulation, and Section 3 is simply inapplicable, which I understand. But we say that approach begs the question, because the question is whether the CJEU would interpret the arbitration exception as including a claim by a direct action claimant against an insurer, or vice versa, where the policy includes an arbitration clause. And in view of the scheme of the recast regulation and its focus on protecting parties deemed weaker, the CJEU would not necessarily treat as separate or isolated questions whether the subject matter of the claim is arbitration and the effect of the provisions of Section 3 on forum agreements. So in effect, the argument comes to the subject matter of the claims won't be arbitration if the CJEU decides that, as with jurisdiction agreements, arbitration agreements don't bind direct action claimants, including in relation to large and marine risks. And it's quite clear from Assens, and we don't need to look it up because my learned friend took the court to it yesterday, but the principal paragraph that one relies on, just apart from the result, is paragraph 39, where it says, it's clear that the situation of a third-party victim of insured damage is even further removed from the contractual relationship involving an agreement on jurisdiction than an insured beneficiary who did not expressly consent to that agreement, i.e. The Palou case. And in my submission, there's absolutely no difference between the case in Assens and this, save that here, the forum clause is an arbitration agreement, and there, it's an exclusive jurisdiction clause. And just for the court's note, I think that's really where the argument on consent comes in, because it's not that the conditional benefit principle can't in any case provide sufficient consent for the purposes of an exclusive forum agreement. Of course it can, see the decision of the Supreme Court in the Atlantic Conference. But the CJEU has said that in a third-party direct action case, there's insufficient contractual proximity to constitute consent. And the distinction between, I suppose, our case and Assens, distinction between our case and Assens on the one part and the Atlantic Conference on the other, is that in the latter, the bank was bound by the conditional benefit principle because it was a loss payee and was an equitable assignee of the insurance policy or its proceeds. And as explained in the Atlantic Conference by Lord Hodge, EU law recognises that a person not a party to a jurisdiction agreement can nevertheless be bound by it if, as a matter of national law, they're regarded as successor to the rights and obligations under the contract.
You're focusing on, or you're putting the case in terms of whether the direct action claimant, the injured party who's not a party to the contract of insurance, is bound by the arbitration clause. But do you accept that that is the same question, whether you are asking the question about the arbitration exception, or about whether there could be a stay under the New York Convention?
In my submission, they can't come to the same thing. Well, I mean, under the New York Convention, as a matter of English domestic law, certainly, it is thought that if you become bound by an arbitration agreement by reason of the conditional benefit principle, the award which is produced would be enforceable abroad under the New York Convention, And I suspect that if a foreign court applied a similar principle, the foreign award would be enforceable here. But because of what the EU or the CJU has decided, in essence, in terms of a injured party, not anyone who takes the benefit under the conditional benefit principle, but in the specific case of an injured party, they are too far away from the contractual or the contract of insurance or the forum clause to be bound by it. And therefore, when one is looking at allocation of jurisdiction under the regulation, the relevant clause is if you like, not to be taken to bind the third party.
Yes. Well, but I mean, I'm interested in the question whether the club would have been entitled to a stay under the New York Convention, which I hear Mr. Young yet again say is the word.
I'm sorry.
I know.
I'm sorry, my lord. I should have the mute button pressed.
I know the state. Yes, I know the state's case on that, but
Yes, I mean,
but the question, or that question would be answered depending on the court's view of whether the injured party is bound by the arbitration clause, whether as a matter of conditional benefit or otherwise. And the only justification the court could have for refusing a stay would be that it's not bound by the arbitration clause. Do you accept that so far?
yes, if the court is deciding between an application to the New York.
And you're inviting a conclusion that the court would say that it's not bound by the arbitration clause because of the provisions of section 3, when recital 12 says that nothing in this regulation, not even section 3, one might add, prevents the operation of the New York Convention, including its provision about stays. I mean, what's wrong with that?
It's simply because one has, in my submission, one has a tension between the two policies. In the recast regulation, one has the arbitration exception, and policy behind that with the New York Convention and excluding arbitration, but also the policy of protecting the weaker party in matters relating to insurance and consumer contract. And one simply has a direct conflict between the two in these circumstances. So, I mean, just so I'm just looking at it sort of logically, where one has a person, even in this case, forget about the states, the individual fisherman or someone in Spain, to say, looking at it from an Assan's perspective, well, if they are not bound by an exclusive jurisdiction clause because they are deemed to be the weaker party and they are outside. So the insurer in that situation can't impose the jurisdiction clause on them, but an insurer with an arbitration clause can do precisely that. So one has the same type of claimant in the same type of situation with the same matter, and one treats them entirely differently, simply by reason of whether the insurer happens to have included an arbitration clause in the policy or an exclusive jurisdiction clause in the policy. And the way I would submit the CJU would look at it is that if one were to allow that to be the case, then insurers can simply waft aside the protections of Section 3 by including arbitration clauses rather than jurisdiction clauses.
Yes, I see.
I mean, that's really it. And one only comes to it via an interpretation of the scope of the arbitration exception, where there's where a party is a direct action claimant, a complete third party to the insurance contract. So cases such as the Atlantic Confidence don't assist, where you're not conditional benefit, of course, but you're not concerned with that type of situation. So I mean, the court has my submissions on that. I'm not sure I can say.
Okay, thank you.
Any further. Could I just speak to Mr. Young?
You can.
Not really, but I'm not
Okay,
sure.
don't worry, I don't worry,
I
don't
understand those points, but
Yeah, okay. Well,
so I'm just not
doesn't
sure
matter.
it meets the issue. If I haven't done this well enough,
No, you
and
don't.
I may well not have done this well enough, then Mr. Young can sort of speak again and clear up my.
I'm sure you've said what can be said.
Yeah,
Indeed, that's rather my thinking on it. In which case, one comes to the question of allocation of jurisdiction within the regulation. So, proceeding on the hypothesis that we are outside of the arbitration exception, and the question then becomes: firstly, are we within the scope of Section 3? If we're not within the scope of Section 3, are we into the question of simply domicile, the general rule, or can the club establish that England is the place for the contract to be performed? So, dealing with the first issue, are these matters relating to insurance? If the club's claims are matters relating to insurance, and also if we are taken to be injured parties, then Article 14.1 of the Recast regulation applies, such that the only courts which have jurisdiction are the home courts of the states. I think that much, at least, is common ground. Now, the parties are agreed that the judge identified the correct test or principles from the authorities, and in particular the Atlantic Confidence. And my learned friend took the court to them earlier, but they're set out at paragraph 122 of the judge's judgment, and my Lord Justice Mayles asked my learned friend earlier whether he accepted the judge's summary, and he said he did, subject to perhaps the paragraph relied upon from the Attorney General in Quebec, and he said that the judge didn't consider what was said in Quebec, and so that is to be taken into account. I think really all we would say about that is that whilst that's what the Attorney General said in Quebec, the court in Quebec didn't follow or endorse or indeed say anything about it. And so in my submission, it doesn't represent the law. The law is, as I've stated, by the Supreme Court in the Atlantic Confidence, as summarised by the judge. And really where one gets to with the judge's test is that the court looks to see whether, as a matter of substance and reality, and applying common sense, the proceedings can be fairly and sensibly said to be matters relating to insurance. Now, for completeness, I just mentioned, and it's in our reply skeleton at paragraphs 19 and 20, that when we were doing some of the updating on the authorities before the reply skeleton went in, we came across that a reference had very recently been made to the CJEU on what constitutes a matter relating to insurance. And we set out the relevant authorities in those paragraphs. Now, we had a look to see the precise formulation of the issue, and I can't see what it is. However, in the context of the cases themselves, it appears to be likely that the reference will have been made in the context of joining a third party to a claim against an insurer in respect of an uninsured excess, with the question being whether that claim can be a matter relating to insurance. So it's quite a different context to our context, and so the reference to the CJEU may or may not provide a useful answer. But certainly, I think the state's submission would be that the law is as stated in the Atlantic Confidence, and whatever the CJEU may say in due course ought not to prevent that test being applied. Now, in very brief summary, the judge's reasoning is set out at paragraph 123 of his judgment. It may just be worth just having it in front of you, Lordships, just so you have an eye on it. The reference is Core 1, Tab 7, page 193. But what he essentially says is that interposition of the English judgments doesn't mean the claims don't relate to insurance, as was the case of the settlement agreement in the Atlantic Confidence. He said, secondly, that the essential purpose of the judgment's claims is to seek to ensure compliance with or redress for non-compliance with obligations which derive from an insurance policy, including its pay-to-parade provisions. And thirdly, he said that the states have sued in the judgment claims because they proceeded with their civil claims in Spain and have obtained and are relying on the Spanish judgment, which finds the club liable by reason of the insurance policy which it issued up to the limit of that policy. So I propose just to address what the states say the nature of the club's claims is, and then address the club's criticisms briefly of the judge's reasoning. Now, well, actually, I might do that the other way around. I'll start with the criticism. I mean, what the club essentially says is that insurance is part of the background. It's not the subject matter of the claims. This has nothing to do with insurance law. The fact this arbitration agreement is in a contract of insurance is pure happenstance. What is important is the obligation to arbitrate. That, says the club, is the essential nature of these claims.
And I think they say also that the arbitration clause is a separable agreement.
Yes,
from the
they.
insurance company.
I mean,
That's
they.
a point which
They do now.
Yes.
Yeah, but I mean, in my submission, that doesn't make any difference actually to the nature and content of the claims. Certainly, the aspect of separability doesn't. The difficulty, as a matter of analysis, I think, which the club faces at this stage, is that on this hypothesis, the court would already have decided that the essential matter of the claims is not arbitration. So it's not to say that these claims are nothing to do with arbitration, but the court's already concluded that is not their essential subject matter. Otherwise, we aren't within the scope of the regulation at all, subject to assents. Which leaves the question, really, what are the claims related to? I mean, what is now clear, we say, is that the Section 66 judgments, being declaratory, do not produce any positive obligations for the states to do anything. They simply declare the effect of the arbitration clause and the result of that on the Spanish claims. So, to the extent there can be an actionable obligation to abide by an English judgment, there's nothing to abide by. I mean, the obligation just has no content. There is no obligation. So, in this slightly odd situation, an analysis of the content of the obligation sued upon probably isn't very useful. But if we look at the purpose of the club's claims, which is one of the ways of looking at it, and it's one of the ways my learned friend looks at it, and he says, again, the purpose is really to protect the right to arbitrate. We say that the purpose of the club's claims is, in fact, to seek damages, to compensate it for the existence, the enforcement of the Spanish judgment. What the club is doing is seeking indemnification for the financial consequences of the states having obtained the Spanish judgment. It's the Spanish judgment which creates any loss, and it's that which imposes liability on the club for which it seeks compensation here. And the liability is imposed on the club in Spain in its capacity as insurer. And we say that the loss is, in effect, likely to be the amount of the Spanish judgment, or the amount which any states manage to recover from the club, so that in effect I suppose the amount of the loss is really the difference between nothing and whatever the states succeed in recovering, or to the amount or the extent to which the Spanish judgment is recognised and enforced abroad. And you say, well, why nil? Because of the effect of the paid to be paid clause and the effect it's been declared to have in the awards and the Section 66 judgment. Because that was really the purpose of the award in the Section 66 judgment. Everyone's talking about the agreement to arbitrate. The purpose was to get a declaration of non-liability based on the pay-to-be-paid clause to insulate the club from any subsequent Spanish judgment which declared it liable as insurer. And so, looking at the matter another way, the Spanish proceedings, so a direct action brought by the states, I mean, it's just obviously a matter relating to insurance, and my learned friend accepted that earlier. But the states are the targets of these proceedings precisely because they are the injured parties in Spain enforcing a direct right of action against the club under a Spanish statute. But also, as we've been told previously, seeking to take the benefit of an insurance contract. So the club's only liability, only interest rather, in all of this is its liability insurer, and because it wishes to avoid liability under the contract of insurance by enforcing and upholding the enforcement of the pay-to-be-paid clause. And it's that which we say is the focus of the proceedings. That is the substantive right available to the club, and it's that right which enables it to claim substantial damages. And it's really those damages which are the focus of these proceedings. We would say that rather than insurance being somewhere in the background, it's the whole point of the claims. And slightly tangentially, I would just mention that there was quite a lot of discussion yesterday about the state's right to benefit from insurance being qualified by the obligation to arbitrate under the conditional benefit analysis. I accept that for present purposes, but in my submission, what really qualifies the state's rights and its ability to succeed in relation to a direct action or the Spanish judgment is what qualifies its ability to benefit is the pay-to-be-paid clause and the effect which has been given to that clause. I think we would also just add that whilst it said that really the focus of these proceedings are arbitration, and while I would accept that arbitration was certainly the background to sort of the process, the dispute resolution process that got us here, arbitration is just that. It's a dispute mechanism process. And it's that process, if you like, which the club has tried to, or has used, to enforce its ability, to vindicate its ability to rely on the pay-to-be-paid clause. It could have been an English jurisdiction clause as well, because as long as you're before probably an English court or an English tribunal applying English law, then it will uphold, firstly, yes, the effect of the arbitration agreement, but also, more importantly, the effect of the pay-to-be-paid clause. So that, we say, is the subject matter of these proceedings. And just going back to the test and the proposition that it's happenstance that the arbitration agreement is contained in an insurance contract, for the purposes of the test identified in the Atlantic Confidence, a claim can relate to insurance while also relating to other things. The Supreme Court distinguished how one looks at Article 7.1 and a matter relating to a insurance contract and matters relating to insurance. And moreover, it's a rule that enforces the general domiciliary rule and is therefore to be construed liberally. So we say that the claims do relate to insurance, but if and insofar as they do also relate to other things, that doesn't preclude them falling within Section 3, as long as they can fairly and sensibly be said to relate to insurance. A point which my learned friend made earlier was that one of the criticisms the club makes of the judgment is on the basis that this case is fundamentally different to the Atlantic Confidence. One simply, the judge ought not to have relied upon or used as part of his reasoning the fact that the settlement agreement was interposed in that case and it didn't make any difference. Whereas he says the judgments here are interposed and that ought not to make a difference to the analysis in terms of the distance, if you like, one has travelled from arbitration. And the club says, well, the judgments are the source of the claims, and there's simply no relevant analogy can be drawn between the judgments and the interposition of the settlement agreement in the Atlantic Confidence. However, we say that all the judges is referring to in his judgment, and it's a completely fair point to make, is that just because the judgments have been interposed here, if you like, between the insurance contracts and the claims now being made, that doesn't mean the claims don't relate to insurance. It's just that the judgments don't break the link between insurance and these claims as a matter of subject matter. And whilst Section 66 judgment can be obviously the juridical source of the claims and the judgment claims on an English law analysis, standing back and looking at the subject matter of the proceedings, that's fairly said to be, we would say, insurance and the pay-to-be-paid clause. And I would just make the point, just briefly, that the first instance in the Atlantic Confidence, Mr. Justice Tier made the point that when applying the test, one ought to get not get too hung up on the juridical nature of English domestic claims when working out whether Section 3 of an EU regulation ought to apply, and that one had to take a rather broader approach. The final criticism, I think, made by the club is that, well, there are other, but the final principal criticism of the judge made by the club, it relates to paragraph 124 of his judgment. And if I could just ask your lordships to look at what the club says at paragraph 130 of its skeleton. Right, if I can ask if your lordship just read 129 and 130.
Sorry, is this their skeleton or of yours?
Their skeleton, club skeleton. So, 4-1. And they're referring to paragraphs 123 and 124 of the judge's judgment.
Which ones to read? 129 and 130?
129 and 130, where they quote from the judge at 124 and says his reasoning is unsatisfactory. And at paragraph 131, the club goes on to criticise the judge for purporting to approach both issues on the basis that it was the nature of the claims that was determinative, but says that in fact he did not do that. And did something else. All the judge was addressing at paragraph 124, which is there quoted, was the argument made to him by the club, which was recycled earlier today, that if the claims weren't close enough to arbitration to be within the exception, they also can't be close enough to insurance, because insurance is even further away, the club would say, than arbitration. And the judge at paragraph 124 said, well, that reasoning isn't sound, underlying the argument, while superficially attractive. And the points he made were in my respectful submission, completely right. He said, the tests governing whether a claim is or is outside of the arbitration exception and in or out of Section 3 are different. Therefore, just because you've carried out an analysis under through Transport 1 on the basis of the essential subject matter of the arbitration agreement doesn't tell you the answer about what the subject matter is for the purposes of Section 3, because the purpose of the existence of the arbitration exception and Section 3 are different. One test does not result, or the fulfilment of one does not result in the fulfilment of the other. And so one can't just bank the conclusion that the claims are too far removed from arbitration and apply the evaluative analysis under Section 3. The judge says that for the Section 3 analysis, you assess the nature of the claim independently of the analysis that has already been carried out in relation to the arbitration. And that was all the judge was saying. And whilst the club criticises him for saying he was going to be assessing the nature of the judgment claims, and they say, well, he didn't do that, he actually looked at the purpose. In our respectful submission, he did both. The judge analysed the nature of the judgment claims, he looked at the purposes of the judgment claims, and concluded that the purpose was fundamentally insurance.
But you prefaced your submissions on this point by saying that it arises on the assumption that arbitration is not the essential subject matter or principal focus of the claims, which I thought was effectively you saying that club starts a goal or two down.
Well,
but you're now saying they're distinct and independent questions.
No, no. Forgive me. I may well have. I probably conveyed that wrongly. I did start the analysis by saying, if one is already in the stage of Section 3, one is already within recast regulation, so one is outside of the arbitration exception, and therefore the essential subject matter cannot be arbitration. The judge was, and what I'm saying here is that he was addressing an argument that, well, because you're outside of arbitration, arbitration is closer to the subject matter of the judgment claims than insurance. So if you're out of arbitration, you must be out of insurance. The judge says, no, they're entirely different things. The arbitration exception is different from whether you fall in or outside of Section 3. The subject matter test for the arbitration exception is one thing, essential subject matter. The test you apply on Section 3 is different. And if you like, a broader evaluative analysis applies under Section 3 than it does in relation to the arbitration exception. And moreover, one is looking at different things for the arbitration exception, because one is looking at curial role of the court and New York Convention, principally, matters relating to insurance. One is looking to see essentially not if insurance is the essential subject matter of Section 3, because that's one test, but whether it's fairly and squarely part of the nature and purpose of the proceedings. In my submission, Section 3, whether you're in or out in terms of a matter relating to insurance, is a broader analysis than arbitration.
Okay.
I'm just checking the time. The next topic is injured parties. Before my learned friend's submissions today, I thought that really the only argument was that based on the capacity in which the states were sued. But it appears that what is actually being said is that Article 14.1 is of no application where the states are defendants, and one is looking at where the club has to sue the states. This was a debate which was had before the judge. And we said, and we say again, that in a nutshell, given where the European authorities come out on classifying injured parties as the weaker parties and having the protections, if you like, of the first part of Section 3, so Article 11, it simply has to be the case that they are given the protection of Article 4.1, i.e. they have to be sued in their home court. I mean, throughout the regulation, that is the principal, well, it's the basic domiciliary rule, but it's also the principal way in which weaker parties are to be protected. They are sued at home, and in the insurance sections, they're also given a supplemental right to sue insurance at home. So they are given more beneficial treatment under the recast regulation. Now, if I could just ask the court to turn up briefly the recast regulation in bundle B1, tab 2. One, I could just ask you to go to start of section 3 on page 351/8. I'm just going to give your lordships a number of specific points which will, I suppose, make good that proposition that injured parties take the benefit of Article 4.1. The first is that if one looks at Article 11, an insurer domiciled in a member state may be sued in the courts of the member state in which he's domiciled in another member state in the case of actions brought by the policyholder, the insured, or a beneficiary in the courts of the place where the claimant is domiciled. and then one goes on to the provisions where they're a co-insurer. Now, in that article, there is no mention of an injured party, but I think we need to go to the case. But what the CJEU did in the case of Odenbright, and for your Lordship's reference, that is at B2, tab 24, and the relevant paragraph is really 26. The ECJ expanded the list of what is now Article 11B to include reference to an injured party. So it held that injured parties could sue insurers in their home court rather than going to the court of domicile of the insurer. Now, one might have thought that, given that's what the ECJ held, that someone would have changed the language of the recast regulation to make that clear, but they didn't. But Odenbright remains good law. And we say that, really, in order to be consistent with that decision, it's fairly obvious that if the injured party is to get the benefit of Article 11, it should also get the benefit of Article 4.1.
14.
14, forgive me. My lord, 14. And to allow it to do that would also be consistent with the recognition in that case and in Quebec and the Atlantic Confidence that an injured party falls within the category of weaker party given automatic protection under Section 3, no matter what their individual characteristics. And as we say, the principal way a weaker party is protected is by being sued and allowing it to sue in its home court. For the court's note, the European Court of Justice in Quebec, I think I just need to give you the reference, but it's B2, tab 28, and the relevant paragraph is 28, made the point that the purpose of Section 3 is to allow the weaker party to benefit from more favourable rules. And if that is the case, and if injured parties are categorised, which they are, it's common ground, as weaker parties under the recast regulation, then there is no reason, in principle, why they would not be able to benefit from the rule that the insurer has to sue them at home. That, apart from anything else, reinforcing the basic domiciliary rule, which a defendant would be entitled to in any case.
But we've jumped straight to injured party, but can I ask you,
Of course.
first of all, do you argue that the states in this case were a beneficiary or not?
Yes, I do. We do.
Right. And then, if you're wrong about that, do you adopt the argument, which essentially my Lord Justice Mayles was putting, that Section 3 is exclusive once you've got to matters relating to insurance, because Article 10 says jurisdiction shall be determined by this section. Article 14 is the only one which identifies where the insurer may bring proceedings, subject to the exceptions in 13.3, I think, and 15. And so irrespective of means irrespective of, full stop. That doesn't matter whether he's a policyholder, insured, beneficiary, injured party, Uncle Tom Cobley, anybody else. And that, as I understand it, was one of the reasons adopted by Mr. Justice Butcher when he said Article 14.1 just applies to all defendants.
Yes, that's right. But once you're into the subject matter of Section 3, then it is an autonomous mandatory code dealing with insurance matters.
So although you've jumped straight into injured party, if you're right on either of those points, we're not interested in injured parties, are we?
My lord, I'm afraid, yes, that's right. It's probably paraphrasing on my part. One starts with the subject matter of what is covered by Section 3. But on your Lordship's analysis, I hadn't quite appreciated that the point had gone quite as far as to say that once you're into a matter relating to insurance, any defendant can take advantage of provisions no matter what capacity. So if they're not an injured party beneficiary, policy holder, then those people can also take the benefit of Section 3. I didn't think, I will stand to be corrected, but I don't remember going quite that far before the learned judge.
Well, that's certainly how I read what Mr. Justice Butcher said.
Yes,
but it also seems to me to be justified by Article 10 suggesting that this is in Section 3. Once you've decided that you're dealing with a matter relating to insurance, you're going to find the jurisdiction answer here. You're not going to have to go to some other part of the regulation to find it.
Yes.
And that necessarily means that you treat Article 14 as definitive as to where the insurer may bring any proceedings in relation to matters relating to insurance against anyone, subject, as I say, to the exceptions that one may find which exclude it in Article 15 or counterclaims and so on.
I mean, that's on the basis of the wording, well, the combination of the opening of Article 10 and Article 14.1, that is the natural meaning of the words. I suppose I would say that I don't quite need to go that far because certain categories of defendant claimant are identified within Section 3 and the states fall within at least one of those categories. So in terms of the wording of 14.1, irrespective of whether he is the policyholder, the insured or a beneficiary, we say that certainly isn't exclusive in terms of those three capacities, and the wording of that is wide enough certainly to encompass an injured party.
But that involves you accepting that what Article 14.1 means when it says irrespective of, is it means if he's the policyholder, insured or beneficiary, or you say necessarily follows injured party. But that's all, those are the categories of people who can take advantage of Article 14, although the introductory words are, this rule applies irrespective of whether they're in any of those categories. I mean, I'm not urging you to take a point you're not taking.
No,
but I had understood that to be essentially an element of the judge's reason.
I know. Well, when I went back and read the judgment,
if you're not seeking to support it, then that's.
Well, no, I mean, I reread it, and I have to say I didn't remember him going quite that far. But that is how I reread the judgment once I looked at it. And then when I looked back at the wording of the article, I thought, well, that is sustainable on the wording of the article. I suspect what Mr. Hancock will say against me is like the judgments such as the Atlantic Confidence and the preceding European authorities. I'm not on that part of the argument. Sorry, Mr. Young is keen for me to make the point about beneficiaries. Sorry. I'm going to come on and make the point about beneficiaries, but that's a separate argument. I'm saying that the clubs are injured parties. I'm also going to say the clubs are beneficiaries, but that is the next part of the argument. This part is a different one. What Mr. Hancock will say is that the decisions in the Atlantic Confidence and the preceding European authorities say that these classes of defendants, say beneficiary, policyholder, are those which are deemed to be worthy of automatic protection, no matter what their economic strength, and that if you want to broaden that protection out, you have to justify it by reference to the purposes of the recast regulation. And that is what those decisions say. But just on the wording alone of Section 3, if you're into the subject matter of insurance, then I would agree with my lord that that is the natural reading of the word irrespective in Article 14.1.
I mean, the widening of Article 11.1b is in order to widen a category of claim which derogates from the basic domiciliary principle. Article 14, if it means what the judge held it means, doesn't. It reinforces the domiciliary rule.
Yeah. Exactly. So it's not a derogation. It needs to. Well, it's not a derogation. It doesn't need to be construed restrictively. So if the natural meaning of the words is that once you're into the subject matter of Section 3, Article 14 applies whatever capacity the person is sued in as a defendant. Then Section 3 applies. It's simply done on the basis of subject matter.
Mr. Hancock was right. Article 14 should read, an insurer may bring proceedings against a policyholder, the insured or a beneficiary, only in the member states in which they are domiciled.
Rather than the defendant, yes. I mean, I agree. And it's odd because I think this is the only article within this section where the defendant, as opposed to a particular specific capacity, is referred to.
As my lord says, if it's not got that wider interpretation, then the question is what provision is there for an insurance-related claim by an insurer against a defendant who doesn't fall within one of these three categories?
There wouldn't be one unless you were to read this article in that way.
Yes, but you don't seem to be, as far as I understand, jumping on the main point, which was, it seems to me, was the basis upon which it was decided by Mr. Justice Butcher.
No, it was one of the ways. There were two elements to his decision. This is the first element. The second one, you've got a sufficient connection with the capacity of injured party. Anyway, I'm not. I suppose I'm. You know, it's quite easy to sort of jump on things which are proposed to you from the bench. It's you know, and
was this another example of tentatively?
in the context of the beneficiary argument, perhaps also in the context of Assens, I was perhaps more tentative than Mr. Young. But I mean, if you're comparing me and Mr. Young, I will always be more tentative.
Sometimes be very disarming.
I don't think Mr. Young has ever argued anything tentative.
Exactly. Which is why it's just the contrast between the two of us, I think, which led to it's the only place he referred to either of us is in that context. I think, to be fair before the judge, I thought I didn't need the beneficiary argument because I thought we were pretty clearly injured parties.
I agree.
And so I was not focusing on beneficiary, as I probably won't focus on it today because we simply come within injured parties. But no, I mean, it's the construction I ran before the judge and which he adopted. I can't remember whether I went quite as far as to say all defendants, but I certainly went as far as to say we're included within that.
Yes.
And I do so again. And that, I think, is quite a safe submission. The broader approach is open, my Lord Justice Phillips' reasoning, and on the wording of the provision. And I would adopt it. I was just being slightly cautious, I suppose, in trying to reason it through before I did.
All right, well, having done that, where do you want to go next?
There was just one more point on why we say that an injured party does take the benefit of 14 subsection 1 because there's specific provision made subsequently in the regulation. If I could just ask your Lordship to look at Article 26.2, which is, I think it's just on the next page. It says, in matters referred to in sections 3, 4 or 5, so that includes the insurance section, where the policyholder, the insured, a beneficiary of the insurance contract, the injured party, the consumer or the employee is the defendant, the court shall, before assuming jurisdiction under paragraph 1, ensure that the defendant is informed of his right to contest the jurisdiction of the court and of the consequences of entering or not entering an appearance. So the contents of that presuppose that a defendant who is an injured party is specifically referred to, has a right to be sued in their place of domicile in a matter coming under section 3. Were it otherwise, it would not be necessary to warn the court, which is not that of the injured party's domicile, that it has to warn them about their domiciliary right. So I think that deals with the argument. I think it's the first in the order of my learned friends' 4 arguments about the application of Article 4.1. The second limb of his argument is if the states are within the scope of Article 3, or if this is a matter relating to insurance, and if 14.1 does apply to an injured party sued.
Sorry, just going back to your Article 26 point, is that new in the recast regulation?
I don't believe it's given a new number. It had a different number before, but it's...
Did it? Where did it
Let me
go before?
Oh, is it new? I'm off.
It looks to me as if it's new, in which case you made the point earlier that it's a bit surprising they didn't add the word injured party in where they were talking about defendants, but it appears they did in Article 26, even though they didn't carry it through into Article 14.
Yeah.
Yes, okay.
Probably slightly dubious.
Yeah, thank you.
Drafting. But it seemed to me that
Well,
that had to be the import of Article 26 too. So the second limb of the club's argument is we're not sued in a capacity of an injured party, and so even if, therefore, Article 14.1 can apply to an injured party in its capacity as a defendant as opposed to a claimant, we're not sued in that capacity. I mean, the judge found his second holding in relation to why we were entitled to take the benefit of the injured parties provision was that even though the states were being sued for having failed to abide by the judgments, they were still injured parties for the purposes of Section 3 because the claims were sufficiently connected to the liability insurance and the state's claims on that insurance, paragraph 131 of the judgment. The club claimed it had suffered loss by reason of the states having sued it as injured parties in a direct action in Spain. So that's the sort of subject matter connection test. And we say judge's reason, again, correct, because if it wasn't, insurers could void Section 3 by framing their claims in a particular way, despite the fact that the injured party was only made a defendant because the insurer, or rather because the injured party had sued the insurer in a direct action, as it was entitled to do under the applicable national law. And really, I think one takes it from the structure of Section 3. I mean, we don't need to go back to it, just looked at it in some level of detail. But the only subject matter test is, as my Lord Justice Popplewell identified, the opening words of Article 10, in matters relating to insurance, jurisdiction shall be determined by this section. There is no definition of policyholder, insured, beneficiary, injured party. And there's no indication of what it means to be sued in a particular capacity. So really, Section 14.1, or rather Section 3, assumes that Article 14.1 will apply where a matter relates to insurance and an injured party brings a direct action against an insurer, and the insurer then sues the injured party. And in my submission, there's good reason for that, because where the insurer does that, sues the particular person who is the claimant in the direct action, it will be because that person is an injured party. And that is the position in this case. The states are sued because they have sued the club in Spain by a direct action as injured parties.
So it's my fault. Are you saying both? Firstly, that Article 14 applies to injured parties, full stop. The states are injured parties, full stop, irrespective of the capacity in which they're sued. Therefore, 14.1 applies, and you're not concerned with the capacity in which an injured party is sued? Or are you saying that you accept that if you're an injured party, you have to be sued in that capacity, but that is the capacity in which the states are sued in this case?
I'm saying I don't accept you have to be sued in a particular capacity. There's simply nothing in the wording of Section 3 which would indicate that is the case.
Yes.
And logically, that would be because if you are an injured party and you are sued by an insurer, it's going to be because you brought a direct action claim against the insurer, or the insurer wants to stop you from doing so, or wants a negative declaration to get in there first with its right before, well, as happened here, you get a judgment on liability via your direct action. And so in those circumstances, that's the very situation where, I mean, the recast regulation in Article 14 must apply.
So that in those circumstances, you say, do you, that the injured party is necessarily sued in the capacity of injured party?
In my submission, yes. I it's very difficult to see what other.
So you say your answer, my lord, is both.
Yes. Well, yes. Yeah. I don't accept capacity as relevant, but
Yes.
logically, I mean,
If relevant, you say that was the capacity.
Exactly.
Yes.
Exactly. Both as a matter of logic internal to Section 3 and the purpose of the regulation, but also in terms of, in this specific case, what has happened here. The states are sued because they are injured parties who have brought direct action proceedings in Spain. You've got that direct link between the two. And if that link is needed, then we have satisfied it.
Yes, I see.
In which case, I don't believe I need to labour that point. I had some more notes, but your lordships have the point. In which case, I was proposing to move. It's quite a brief topic, so I could probably do it before 4:15. Is the question of whether we're beneficiaries.
Yes.
So the additional capacity of beneficiaries, in addition to injured parties. Now, as we say, we don't need it, but in our submission, well, I think I should start from the point that there's nothing in the wording of the regulation, Section 3 in particular, or the European jurisprudence, which identifies as a matter of principle who or what is a beneficiary of an insurance policy. Presumably, it ought to have an autonomous meaning under the Recast regulation, but there's simply no indication as to what that is. Now, there are a couple of decisions within the bundles which touch upon this, and they're the only ones, I think, which we are aware of. The first is the Atlantic Confidence in the domestic context, where the bank was a loss payee and an equitable assignee of the policy, and it was classified as a beneficiary for the purposes of Section 3. There was also the decision of the ECJ in 2006 in a case called Pelou. We don't need to turn it up, but it's bundle reference B2, 23. It involved a claimant that was a subsidiary, and the parent of the corporate group had taken out a group liability policy. And the subsidiaries were beneficiaries of the policy by way of cover being extended to them by way of an addendum. So the claimant subsidiary was a beneficiary because it was a named beneficiary of the insurance policy. So thus far, in the case in the domestic context and the European context, it's fair to say that beneficiaries have been taken to be someone with a direct, if you like, connection or a close sort of nexus with the insurance contract. But there's nothing in the wording of the regulation or the authorities which indicates that there's that it's necessarily limited to parties named or the assignees or of the policy. Now, the Supreme Court in the Atlantic Confidence said had the bank issued a claim in relation to the insurance policy, it would have been bound by the terms of the policy, including the exclusive jurisdiction clause by reason of the conditional benefit principle. So the bank's right to benefit from the policy would have been qualified by the arbitration agreement. Back in 2013, the court, Mr. Schaff, and then subsequently followed by the court, declared that the states were bound by the arbitration agreement by reason of the conditional benefit principle. And we were bound because we were said to be trying to take the benefit of the insurance policy without, if you like, respecting the qualification to which it was subject. And I think we say as a matter of logic, but also as a matter of fairness, you can't have it both ways. Spanish law gives a right of direct action, and English law says, well, you can have it, but only on the terms of the insurance policy. And in those circumstances, we say we must come within what is a broad term in the recast regulation of beneficiary. Now, we would accept that injured party is linked in the regulation to the person who's pursuing a direct action. So it is, if you like, given a specific classification within the recast regulation, and also regulation uses different terms. But in our submission, they're not necessarily mutually exclusive. And it's quite possible for, if you like, an injured party, which is quite a specific group, to be a subset of a broader group, which could be beneficiaries. There's simply nothing that excludes, that says, well, you can only exist in one particular capacity if it's otherwise justified, because we're going to be bound by the contract of insurance and the arbitration clause because we're seeking to take the benefit of it. There's nothing to say that we shouldn't be a beneficiary as a matter of European law or domestic law. And one can also see that under the various sort of national laws within the EU, there are going to be various ways of parties potentially being beneficiaries of insurance policies, and with or without being an injured party. And so, I mean, our very short point is, English law tells us we're taking the benefit of the contract. We should be classified as beneficiaries within Section 3. There's nothing in the European jurisprudence or the English authorities which preclude us from being so. On a common sense interpretation of the language, we should fall within it. But
so far as the cases go, or any other learning you might have identified, there's nothing to extend beneficiary beyond somebody who is either named or contemplated by the contract. Is that right?
I don't know, we haven't found anything illustrative within the writings, the opinions of the various Advocate General or the decisions. And in Pellew, I mean, there's no sort of, if you like, analysis of why a person is beneficiary. It's simply stated and assumed they are a beneficiary because they were named under the policy. And that makes, you know, you're named as a beneficiary under the policy, they're going to categorise you as a beneficiary. But there's nothing, which is why I say, as a matter of principle, there's nothing to guide the court as to what is within or without that term. So,
yes.
And do you say that in liability insurance, most liability insurance contemplates third parties as beneficiaries, because it's very common to have a direct action that third parties can take the benefit of the liability insurance directly against the insurer?
Absolutely. What Mr. Hancock would say against that is well, that's specifically catered for by reference to injured parties. But so in the context of liability insurance, absolutely right. But one can also see that there are other ways in which third parties can benefit from insurance contracts without necessarily being an injured party under, or for the purposes of a liability insurance. The next subject, and I may as well just, I'm going on to a new topic, but it probably makes sense to try and use up time. If not use up time, that's the wrong word, but to keep going, because in order to get through, to leave time for Mr. Young and also Mr. Hancock to come back on their points.
Yes, all right, we'll carry on then just for a little while.
I'll just introduce the Article 7.1 point, because one moves on to Article 7.1 contract, matters relating to a contract to be performed within the jurisdiction. Sorry, forgive me, I think. No, it's not. This is the only special ground of jurisdiction which concerns France, and Mr. Young will address the points on Spain, although I should say that I think the points on Article 7, subsection 2, delictual, are actually very similar, because a lot of the ground is covered by the decision of the Supreme Court, I think, in Marzilla. Now, for the purposes of these submissions, what I'm going to do is park the question of whether there's a serious issue to be tried in relation to the existence of a relevant contract. Obviously, we say there's no sufficiently arguable case in relation to that, but I'll come on to that at a subsequent point. As my learned friend fairly said, the principles are common ground is between the parties, and they're set out at paragraph 164 of the club's skeleton, which you referred to earlier. The only principle omitted by the club is the blindingly obvious one, that this is a derogation from the domiciliary rule, and so is to be interpreted restrictively as opposed to liberally. And the principal questions for the purposes of an application of Article 7.1 are, firstly, what is the relevant contractual obligation, which is the principal obligation upon which the claimant advances its claim. And the second principal question is, where is it to be performed? And the place of performance is to be determined on the basis of national law. So in this analysis, really, it's a domestic analysis, and one has the decision on exclusive foreign clauses in AES, and subsequently the Supreme Court's decision in Martzilla. Now, there appears to be common ground as to what the relevant, or at least purported, obligation is, that being that the states are obliged to abide by, whatever that means, the Section 66 judgments. I mean, the club puts it this way in paragraph 166 of its skeleton. I didn't understand my learned friend to sort of really dissent from this. He said the club puts it as, the relevant obligation is one to abide by the English judgments declaring the parties bound to arbitrate its civil claims in London. And in terms of where one sort of finds this contract, for the purpose of the judgment claims, it's either going to be in this implied jurisdiction agreement under the vis care, or an implied contract arising out of the judgment itself, or the submission to arbitration. And the first question we say, probably I should stop and come on to this, but where I will come on to when we start again tomorrow, is whether the Section 66 judgments impose any obligations on the states at all, such as they could be performed in a particular place. And we say, as a matter of principle, and also based on Zavarco, there is simply no obligation to perform, and thus an analysis under Article 7.1 doesn't get off the ground. But
is that different from serious issue to be tried?
It is, yes. My lord, yes. What actually is it? No, my lord, I think you're right. That would be serious issue. No, I know. In terms of, is there a good arguable case of an obligation arising out of a contract which has to be performed? And yes, it's good. It's serious. It should be tried. So I'm wrong in the first point.
Well, except that good arguable case might be a higher standard.
Well, good arguable case applies to the application of the regulation. Good arguable case would apply to the application of Article 7.1. Whether one even gets to Article 7.1, is there a contract that serious issue to be tried?
Therefore, the need to show the obligation to the standard of good arguable case, rather than merely serious issue to be tried, which is the common law test.
I'm using serious issue to be tried because there's a decision from the CJEU TISM which says that for the purposes of Article 7.1, and the party has to show the existence of a contract, they have to show it to the serious issue to be tried standard as opposed to a good arguable case.
Oh, do they?
So it's a slightly lower. Otherwise, I would go for the higher test.
Yes, all right, fair enough. Well, we'll stop there then and resume at 10 o'clock tomorrow.
My lord, can I just raise one question which is in relation to timing? And that is, I just wanted to make sure that we had a timetable set for tomorrow, because I am conscious that I'm going to need to have some time to reply. Hopefully not very much, but I just wanted to make sure that that the states are finished by lunchtime tomorrow, in order to give me an hour to reply.
All right, well, I think we're not going to rule on that now. Discuss it between yourselves, depending on...
For what it's worth, my lord, as I'll be on my feet before Mr. Hancock, I'll make jolly sure he gets on.
Well, discuss it. What I'm saying is discuss it between the three of you, work out an allocation of time, and tell us in the morning what you've agreed, with a final deadline, as I said, of 10 to 4. But we are supposed to have some time held in reserve, so I'm hoping that we won't need to go that long. Looking at what you told us.
You're going to be going through Harry Ann.